Your Humanities Half Hour is brought to you by the Northern Marianas Humanities Council.
Hapadays and Tero, welcome to Your Humanities Half Hour. I'm Catherine Perry, and today we're listening in on another presentation from the Third Marianas History Conference held in Saipan in September 2017. Keynote speaker Julian Aguon is the founder and visionary behind Blue Ocean Law, a boutique international law firm that services clients throughout Oceania. A native son of Guam, Aguon is a United Nations recognized expert in the international law of self-determination who is devoted to breaking new ground in the areas of human and indigenous rights law. His presentation, Wronging the Rights, a Mediation on Legal Mischief in the Marianas, addresses aspects of the cases of Davis versus Commonwealth Election Commission and Davis versus Guam, focusing on the layered meanings and ramifications of invoking the civil rights legal framework in regards to the political struggle for self-determination.
So this is a picture of Arnold Davis, who on November 20th, 2011, filed a lawsuit against the government of Guam, against the territory of Guam, the Guam Election Commission, and all of its individual members, seeking declaratory and injunctive relief. What that means is he was seeking to enjoin or stop the government of Guam from having or registering names on the Guam Decolonization Registry Law, registering the names of so-called native inhabitants of Guam, or the people whose citizenship was effectuated by Congress's passage in 1950 of the Guam Organic Act. So that was the lawsuit, and it was filed in 2011. It has a long history. It started, obviously, November 2011. We went to court. The claim was that David Davis is alleged that the Guam Decolonization Registry Law and that the native inhabitants of Guam classification in particular violated his constitutional rights under the 5th, 14th, and 15th Amendments, as well as under respective statutes, both federal statutes, the Voting Rights Act and the Guam Organic Act. So that's the basis, that's the merits of the claim. It was filed in federal court in Guam, the district court there, before Judge Gatewood. We won below. We won on grounds of ripeness. Ripeness is this doctrine that federal courts use. It's called a prudential doctrine. It's just a doctrine that you use when you want to try to dismiss a case early because it doesn't present a right controversy. It's not a real case. And the reason why, I'll explain it just to make it easier to understand. The reason why it wasn't right was because the future plebiscite to be held in Guam was not actually scheduled. There was no scheduled plebiscite. There's no date. So there was no, back in 2011, there was no basis on which for the federal court to rule because the plebiscite hasn't been in fact scheduled. So it's purely a hypothetical controversy. So we won below, it got appealed to the Ninth Circuit, then it got reversed. So the court said no, there was sufficient standing and ripeness and sent it back down. So it's called Davis Round 2. And now we're on the merits. We're actually addressing the constitutional arguments raised by the plaintiff in this case. Does the Guam Decolonization Registry Law, in particular the classification native inhabitants of Guam, does it offend the Constitution? Does it in particular violate the 14th and 15th Amendments? So that's the issue now. Native inhabitants of Guam. It's defined as those persons who were made U.S. citizens by virtue of the enactment and authority of the Guam Organic Act and descendants of those persons. That's the actual definition. That is the definition of the qualified class of people eligible to vote in the plebiscite, should Guam ever have a plebiscite. This is all we ever hear about. Tomorrow only vote. Tomorrow only vote. Tomorrow only vote. Like every 5 seconds, the media says, ooh, it's like that scene from Lion King. Sorry, we're gonna just be ghetto. It's like that scene from Lion King, where, just like, Mufasa, say it again, ooh, Mufasa, ooh. Like it's like the hyenas played by Whoopi Goldberg. Anyway, my point is, it's like that. Mufasa is tomorrow only vote. Ooh. Like that's the sort of effect in the sort of dominant discourse. And it's absolutely flatly, categorically imprecise to say only Chamorro people can vote in the vote. And how do we know that? We know that because there's proof in the 1950 census that those people made U.S. citizens by virtue of the enactment and authority of the Guam Organic Act were not only Chamorros. It was in fact a multiracial, multi-ethnic class of people. Granted, it was predominantly Chamorro, but that in itself is insufficient to establish a violation of the 15th or 14th Amendment to the U.S. Constitution, and that is the gestalt of the case. The other really important aspect is the definition I just traced for you. It says, quote, and descendants of those persons. It's almost as if the courts and the plaintiff latched onto one word, descendant, right? Or the single reference to descent, which is an ancestry-based classification. That means your ancestor experienced some aspect of colonization or the colonial enterprise. What I'm saying is your ancestor experienced the harm of colonization, therefore you are entitled to the cure of decolonization. It's a harm and a cure. It's very rational. Like you are allowed to participate in a decolonization exercise if you or someone you descend from actually experienced colonization. That's it. It's not entirely controversial, but there's this sense that ancestry is always a proxy for race. So that's been the guiding sort of theory of the plaintiff's case the entire time. That ancestry, once you see the word ancestry or hear the word ancestry, it's automatically a racial classification. And under the 15th Amendment, you are barred, any state or territory is barred from engaging in racial discrimination or denying the right to vote on account of race. But Guam's position has consistently been for years now that limiting the qualified electorate to Native inhabitants of Guam is not in fact discriminating on account of race. It's actually just making sure that you're rationally, appropriately, entitling or capturing the right class of people. That is, those who experienced colonization and were made U.S. citizens in 1950. Harold Rice. I don't know if you all know him. They call him Harry Rice. Rice versus Cayetano. This is the plaintiff in the Hawaii case, the 2000 case, where the U.S. Supreme Court said Native Hawaiians, where the U.S. Supreme Court invalidated a Hawaii statute that limited those eligible to vote in the statewide election for trustees for the state agency known as the Office of Hawaiian Affairs to install those trustees into state office. So Rice versus Cayetano was a 2000 decision, and it only holds that limiting the right to vote in a state election for state officials violates the race neutrality command of the 15th Amendment. That's not entirely controversial as a legal proposition. But in that case, there's a sentence. It's almost like this boogeyman sentence, right? It's the same Mufasa thing. This ancestry can be a proxy for race. So the plaintiff, in our opinion, as well as the plaintiff in several cases in the wake of Rice versus Cayetano, has simply said that anytime you mention ancestry, it's always racial. That ancestry equals race. But as a writer and as a lawyer, we have to be very careful and mindful of the words that we use. If the U.S. Supreme Court intended to hold that ancestry is a proxy for race, it would have said so. It would have said ancestry is a proxy for race. But instead, it said ancestry can be a proxy for race. And it can be in this scenario when there's no other motivation that can possibly be deduced other than the intent to discriminate on long racial lines. This is the thing, you guys. This is the thing that we've seen in this country. This is not a new rule. This rule has been handed down and is indeed a part of a longer history of U.S. Supreme Court jurisprudence. This idea that when you have a classification, and I'm saying it's not on its face racial, but the intent is so clearly driven and motivated by a racial purpose, the court will invalidate it. A good example of this is Guam versus Lightfoot. It's a case where I think it was the city of Tuskegee tried to enact a redistricting law that took a regular electoral district and made it so oddly shaped. It was like 28 fingers. And so it was like a regular thing went to like some crazy mangled shape. And in that shape, it was drawn for the very particular purpose of capturing no black people. That is a good example of a state whose motivation is so exceedingly transparently obvious that your end result is to enfranchise and disenfranchise solely on racial lines. That was not these other cases. And in the Guam case, it's so abundantly clear that the Guam Congress's attempt merely to cut and paste the exact definition that Congress itself came up with, and we know that because Congress extended citizenship to that very class of people. So here we have Congress creating a category of people and giving them U.S. citizenship. And in the actual committee reports, the Senate and House committee reports saying the native inhabitants of Guam are due their rights of self-determination under the UN Charter. This is part of the U.S.'s international legal obligations. All of that if we were to take these arguments to their logical conclusion, it would mean that we're now obliterating any kind of anything. And this is the problem. A judge has to judge. They have to decide. They have to figure out what's going on here. In this case, Guam is clearly not desiring to discriminate along racial lines, but is merely trying to capture the appropriate federally created class of people for whom it is true that they or their ancestors were colonized and made U.S. citizens in a particular year, and merely take that direct toward that same group of people the right to vote in a purely symbolic plebiscite. So now I'm going to tell you one more difference that it's relevant to know. And I just want to share, because this is all public record, because all of the briefs have been filed in this case. I'm not sharing anything new. I'm sharing all of things and arguments that were made by both sides, and they're both available at the district court level as well as the appellate level. The other big difference, right, is what kind of election did I just tell you about in Hawaii, right? It's a state election for the purpose of installing state officials into a state agency. It will have binding consequences in law on people in real life. It actually is binding and has the operative effect, the weight, the hand of law behind it. And you're actually deciding a matter of public policy with finality, and you're actually installing people into office. That, under the 15th Amendment, is embraced. That kind of election is reached by the 15th Amendment. It's embraced by its protections. A purely symbolic plebiscite, on the other hand, is not. Guam, even if the government of Guam were to hold this election and native inhabitants of Guam were to participate in this plebiscite, the only actual command in statute is that you send the results of those plebiscites to the federal government, in particular to the president and the Congress, as well as the Secretary General of the United Nations. Let me tell you something that's legally significant. They may ignore it altogether. It doesn't bind anybody. It doesn't bind the UN. It doesn't bind the US. It is purely symbolic. Symbolic in a strict sense. And we have always maintained that the 15th Amendment doesn't guarantee, like it doesn't reach this because it's not an election within the meaning of that amendment.
Julian Aguon, this is Your Humanities Half Hour.
Did you know that you can donate up to $5,000 to the Humanities Council through the CNMI Education Tax Credit Program? Donations from individuals and corporations qualify and can be used to offset your local wage and salary tax, BGRT, and earnings tax. Call our office at 235-4785 to see how you can support humanities programs in our community and obtain a tax credit for your donation. Sizuus Maasi, Olomai, and thank you.
Welcome back to Your Humanities Half Hour. We're listening in on the presentation of Julian Aguon made at the Third Marianas History Conference in September 2017 in Saipan, where he spoke on Wronging the Rights, a mediation on legal mischief in the Mariana, looking at Davis versus Commonwealth Election Commission and Davis versus Guam.
This is just the 15th Amendment. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. See, that's another interesting thing. Every race, just the moment you tell me about race, I'm gonna be pissed off. The moment you say white or black, I'm gonna know, because there's no clues, there's no context clues, right? But why was this amendment passed? Race, comma, color, comma, or previous condition of servitude. It's trying to capture an idea. There is only a particular group of people for whom this is true, or previous condition of servitude. I don't know what's happening, but I call it legal mischief because it seems to me that all of these amendments, the 14th Amendment, it's guaranteed equal protection, the 15th Amendment, they're experiencing a profound perversion. It's evolving to the point where it would seem, and this is slightly controversial, that those who are most actively, zealously, and passionately running to the arms of the law for legal protection under the 14th and 15th Amendment are people who historically were never in need of their protection. This is how the law is in danger because it's evolving in exactly the opposite direction. All of this sort of ahistorical, formal race, jurisprudential evolutions are dangerous only because now everything is the same. It's called in rhetoric or whatever, and we would call it the fallacy of false equivalence. Guam is technically and legally speaking a colony. It's technically and legally speaking an unincorporated territory not bound in permanent union with the United States and not destined for statehood. That is exactly the proposition of the insular cases. That Congress is going to preserve, the courts are going to preserve a space that's called a constitutionally exceptional space, a space of constitutional exceptionalism. The only other such space that exists, just so you know, is the constitutionally exceptional space occupied by members of federally recognized Indian tribes. Meaning to say that there is, in the United States, the court still recognizes two tiny spaces and says, y'all can offend the Constitution on occasion. Because y'all have a different set of historical, legal, and political circumstances that warrant a differential standard of review. This is the idea. This is the thing that so many people miss about what constitutional exceptionalism means and what it looks like. So when you hear about the 14th Amendment, right, we always latch into the last part. It's the Equal Protection Clause. This is the Equal Protection Clause. So under the 14th Amendment, with the right to be treated equally under law. That's all it says, right? But how does it evolve over time? One of the U.S. Supreme Court cases is known as the Caroline Products case. And in the fourth footnote in that case, the court announces this new kind of analysis, this new analytical framework for understanding who is being denied equal protection laws. Those who lack political power. Those who actually lack access to political channels of political power to change or ameliorate their circumstances. Those are people for whom the Equal Protection Clause should sort of why a court passing on any case should exercise a heightened judicial scrutiny, because some people, for some reason, set of historical circumstances, have lacked political power and are in particular need of this, right? So that's just one footnote, but it's a famous footnote, and it actually gave birth to the so-called level of scrutiny. Who are the intended beneficiaries of the law's protections? Those who lack political power. So I submit, because Guam is by definition an unincorporated territory whose citizens are denied a whole range of things, including the ability to vote in federal elections for people who make that, I would say that could count as the lack of access to political power. So the whole government itself lacks access to political power. So it cannot just be equated with a sheriff in a southern state wielding his might over black victims. This is not the same. And I think that was one of the things I really wanted to highlight for you, because the Breitbart story came out, and then all of these other stories have come out, just likening Guam to Jim Crow. And there's something incredibly repugnant about that. And I implore you to see that a little bit. I just want to try to recalibrate the discussion a little bit around these cases. Whew, okay, self-determination, right? It's a fundamental right of peoples. The 20th century had very, very little to say about what self-determination means for indigenous peoples, as indigenous peoples. They weren't actually formally accorded the right of self-determination until even the beginnings of it can be traced with the UN DRIP, the United Nations Declaration on the Rights of Indigenous Peoples in 2007. So now, as an international law scholar, I can tell you that I can, if anyone's interested after, I can tell you about the post-2007 evolution of the international legal norm around self-determination for indigenous peoples later. But for now, I have 4 minutes. I want to say something. The right of the colonized people of Guam, the right of self-determination in the Guam context exists, but it exists in its proper context. That is the right as a colonized people, not necessarily as an indigenous people. Meaning, their indigeneity as an element is not what triggers a right. At least not what the well-settled right under binding international law, both customary and conventional. The binding international, that's called fundamental right of self-determination. When people use that language, we're talking about the right of self-determination that belongs to colonized peoples. But in some cases, the two groups overlap. New Caledonia, Kanaki, Guam, there are clear examples where it's just a little bit, the analysis becomes a little bit blurred, because there is a right that inheres in the colonized people of Guam, as well as a right that inheres in the indigenous Chamorro people of Guam, but the latter is a lot newer, and it's not binding to the extent that the former is. So this is much more complicated than I have time to explain here, but what I do want to say is that the opinions of the law are not necessarily the law. So there is settled law, but I think part of the problem is there is a crime the biggest crime of American legal education is the absolute laziness about digging around the views of the rest of the world. This is settled already. It's not an argument. We're not in A versus B scenario. A lot of this is settled law. But we just pretend that it's not. We pretend because the U.S. at this moment in its history flouts international law. Because it's a powerful country, and on occasion it will pay some heed. It will pay some mind to international law. For the most part, it does not. But I'll tell you something. Just like I talked about the evolution of equal protection jurisprudence, this country has evolved. Its political opinion has evolved. When this country was a young country, it be loving some international law. It was all about international law because it needed its protection. So look, in the U.S. Supreme Court Puget Havana case, in the early 1900s, they're like, yep, international law is all part of our law. Yep, we are bound by that. Yep, absolutely. But now, the game has changed. The posts have moved. We just have to keep up. And I think, what I'm saying is we have to dig really, really, really deep and try to summon all of our intellect, all of our, we have to resist all this intellectual flabbiness around all of this. This Chamorro only loan. this just really lazy attitude around understanding the rights. And that's why I wanted to call the talk Wronging the Rights, because there's something afoot here, and it's pernicious, and it feels and looks a little sinister, because there's just not enough context-specific inquiry. But I'm here to tell you, as an international law scholar, that self-determination belongs to a very specialized, exalted status under international law. It actually enjoys its own term, jus cogens, compelling law. The whole world has agreed that certain international legal norms are binding. They're so, the violation of which is so egregious it offends the sensibilities of all of humankind. Genocide is one of them. Prolonged arbitrary detention is like working its way. But genocide is one of them, as well as, sorry, that's what these slides are about, torture in Abu Ghraib. These are jus cogens things. No state can do them. So self-determination, to know that the world community has elevated the status of the right of self-determination to a jus cogens level, it means that people's longing to be free is also fundamental of the highest order. When you go to New York, when you're in Manhattan and you're looking at the United Nations, all you see is a row of flags. Almost all of them would not be flying if not for this norm. The right of self-determination, the remedy of decolonization, is so fundamental, and it gave birth to all of those flags flying. There were so few countries in World War II. And you guys, things can change, things do change. They do. The law evolves when we are passionate and principled and precise and exacting. If you have all of those things, you can bend the law. You can make it go in a better direction. We, in the islands, we exercise jurisdiction, well, if we were a state, meaning a country, and we exercise, if Guam was a country like on any other, being a coastal state, you get to exercise sovereign jurisdiction over 200 nautical miles out, right? Right? We know that. So there's resources. So maybe we could do something. But that's not the point I want to tell you. What I want to tell you is, that's you. That's you. It used to be that a state only had jurisdiction over 3 nautical miles. Why? Because that was the farthest you could shoot your cannon. That was the farthest a state could shoot a cannon. It's the farthest a state could project its power. So it was 3 nautical miles then, 200 now. Who knows? The whole regime of continental shelves. You know that, and I'll just say this last thing. I'll wrap it up. When we're talking about climate change, and you're like, why are you talking about climate change? I'll just tell you. It's a good illustration. It's illustrative of an invitation to push the legal imagination, to think past, right? Under the 1933 Montevideo Convention, there are certain ingredients that every state needs. You have to have elements. You have to meet criteria to be a country. You have to have an actual human population. You have to have an effective government that is capable of engaging in relations with third-party countries. And you have to have an actual territory, an actual space on which to project that power. It's like the cannon. You need all of these elements to be a state, right? Climate change is threatening certain places, certain low-lying atoll nations, who may one day lose one of the essential elements. So what does that mean then? If the Maldives, or if Kiribati, or some Marshall Islands loses one of the 4 necessary ingredients of statehood, it would mean that legally speaking, they're not entitled to be a state anymore. It's like, and if you read some of these contracts, right? Some of these contracts, like documents, these MOUs between governments, talking about envisioning the actual transfer of the entirety of a human population from one place, from place A to place B. That is no longer a contract, it's a eulogy. It's the death of a state. This is how big this stuff is and how much it matters. And if we can bring to the task of this, like every ounce of it, we can marshal our best arguments, and reach for the energy of the other disciplines. The law is much too behaved. The law is going to need art. It's going to need music. It's going to need to pull from all of these other liberatory energies and disciplines to change.
We've been listening today to the presentation of keynote speaker Julian Aguon at the Marianas History Conference in September 2017 in Saipan. Mr. Aguon spoke Wronging the Rights, a mediation on legal mischief in the Marianas. We hope this has been informative and educational. We hope you enjoyed our presentation today. This has been Your Humanities Hour. I'm Catherine Perry.
This program was supported by a We the People grant awarded to the Northern Marianas Humanities Council from the National Endowment for the Humanities. Any views, findings, conclusions, or recommendations expressed in this program are those of the participants and do not necessarily represent those of the National Endowment for the Humanities or the Northern Marianas Humanities Council.